Hello everyone and welcome to our third video tutorial on negligence. In today's video we're going to be looking at damage. Just a reminder of the three elements of negligence that need to be proved in order to find the defendant liable. Firstly, you have to prove that they owed a duty of care to the claimant. Secondly, you have to show that they breached that duty. And thirdly, you have to show that that resulted in the damage. In our first two video tutorials on negligence, we looked at duty of care and then breach of duty, and today we're going to be focusing just on damage. Proving that the defendant owes a duty of care and they have breached their duty of care is not enough for negligence. There also has to be some sort of damage, which might be injury or damage to property, that has resulted from the defendant's negligence. And the claimant must prove two things to prove damage. Firstly, they have to prove factual causation. And secondly, they need to prove remoteness of damage or legal causation. So you have to be able to prove that it was the defendant's negligence that has resulted in the ultimate injury to the claimant. We'll start by looking at factual causation then. To demonstrate factual causation in tort law, the claimant must establish that the loss they have suffered was caused by the defendant, and we use the but-for test to do this. And the but-for test in tort is illustrated in the case of Barnett and Chelsea. And what happened here was our claimant went to A&E complaining of severe stomach pains, and he was also vomiting, and the doctor refused to see him. And he died of arsenic poisoning a few hours later. And although it was proven that the doctor owed a duty and he breached his duty, the medical evidence showed that the claimant would have died anyway, even if he had have been seen, because there was far too much poison in his system at this point. So this case shows us that the but-for test was not met because he would have died anyway. And the breach by the doctor was not the cause of death. This perhaps seems a little bit harsh because the doctor here did owe him a duty of care, has clearly breached it because the reasonable doctor would have seen him, but nonetheless, it wasn't that breach that led to his death. So that's factual causation there with the but-for test. But sometimes it can be complicated by the fact that, particularly in medical cases, there can often be multiple causes of the damage. Where there are two or more possible causes which might have caused the damage, it can be factually impossible to determine which one was the cause. And this has proved really problematic because the claimant is the one who has to establish who was the cause. And that can be really difficult in a medical case. And if we look at the case of Wiltshire and Essex, this was about a baby, a premature baby that was born and given too much oxygen by a junior doctor. And the junior doctor admitted that he'd given too much oxygen, and the baby went blind. Now, one possible cause of the blindness was too much oxygen, but there were actually 5 other possible causes for the blindness because this baby was premature. And because the claimant couldn't prove which cause actually caused the blindness, he was unable to prove causation. So that gave us the principle there that where there are multiple causes, a defendant might escape liability in negligence because the claimant simply cannot prove he was the factual cause. You can see then that this rule can operate really harshly on the claimant, and that was certainly the case for many years. And then we had the case of Fairchild and Glenhaven. Now this was a really, really tragic case, and it was a conjoined appeal involving 3 claimants who had contracted mesothelioma, which is a type of lung cancer, contracted by exposure to asbestos. Now, a number of employers had each negligently exposed these claimants to asbestos. And the problem was that the claimants couldn't prove which of the negligent employers they were working for at the time that they got this lethal cell which triggered the mesothelioma. So that was looking really harsh on the claimants. So the House of Lords made an interesting decision here. And they said that if the claimants could demonstrate that one employer had materially increased the risk of contracting mesothelioma, they were entitled to claim compensation. So that was mitigating some of the harshness, really, from the case of Wilshire. Another interesting case on this issue of multiple causes is something that we call loss of chance. And this is illustrated in the case of Hodson. And this is where the claimant was a young boy who fell from a tree. And he went to hospital and he was given incorrect treatment and he was left permanently disabled. Now, the defendant hospital admitted negligence, but they denied liability. And they said, yes, we were negligent, but we were not the factual cause of this permanent injury. And the evidence showed that there was a 75% chance that the claimant's medical condition would have been the same even if he'd received the correct treatment. So therefore, they couldn't prove causation. So the court here was saying that there needed to be more than a 50% chance that the negligent medical treatment affected the claimant's condition. And this is sometimes called the all or nothing approach. So what we're seeing here is that it can be very difficult to prove negligence against doctors. Proving medical negligence is very, very difficult. The last aspect of factual causation is novus actus interveniens, which we've come across in criminal law before. And I'm sure you recall this means a new intervening act. And this simply says that if there's a new act between the defendant's negligent conduct and the damage, then that can break the chain of causation. And that's because the law's unwilling to impose liability for the deliberate act of a third party. And in this case, there was a novus actus interveniens in the case of Smith and Littlewoods because a third party had actually broken in to the defendant's property and set fire to it. So that was not the defendant's fault, it was a novus actus interveniens. Okay then, so we've looked at the first stage of proving damage, we've looked at factual causation, we now need to have a look at legal causation or remoteness of damage. Remoteness of damage relates to the requirement that the damage must be of a foreseeable type. In negligence claims, once the claimant has established that the duty owes a duty is in breach which has factually caused the damage, they must also demonstrate that the damage wasn't too remote. In this way, remoteness of damage is often viewed as an additional mechanism of controlling tortious liability. Not every loss is going to be recoverable in negligence. The defendant's only going to be responsible for reasonably foreseeable losses. The classic case on this is the Wagon Mound, and in this case the defendant's vessel, called the Wagon Mound, leaked furnace oil at a wharf in Sydney Harbour. Some cotton debris became entangled in the oil, and sparks from some welding works ignited the oil. The fire spread and it caused destruction of some boats that were docked in the wharf. Now, the court said that the defendants were not liable because the damage to the property was too remote, and they held that the damage must be reasonably foreseeable. Crossley and Rawlinson is another example of a situation that was held not to be reasonably foreseeable, and this was where our claimant was injured when he fell down a pothole on his way to put out a fire. And this was held to be too remote because whilst you could foresee someone might be injured putting the fire out, it wasn't foreseeable that someone's going to fall down a hole on the way to the fire. So failed on remoteness there. Bradford and Robinson Rentals, our claimant was driving a long journey in a lorry that had no heater, and his employers wouldn't provide him with a heater. And due to severe weather conditions at the time, he suffered frostbite and he was claiming negligence against his employers. Now, his employers were saying, okay, we can foresee some damage from him being cold, but frostbite is really extreme and that's unforeseeable. But the court disagreed, and they said that frostbite is an extreme form of the type of harm they would expect. In other words, frostbite is an extreme form of injury from being cold. So that was foreseeable and it was recoverable. Similarly, in Hughes and Lord Advocate, there was a sort of similar situation here where boys took a paraffin lamp down a hole and there was an explosion and they suffered burns. And the defendants here, who were arguing the fact that they weren't negligent, were saying that the burns were caused by an unforeseeable explosion. But the court disagreed, and they said that the type of harm suffered was foreseeable, burns. So it didn't matter that the precise way it occurred was slightly unusual, i.e. an explosion, rather than just a burn from, say, touching the lamp itself. So that case again was held to be reasonably foreseeable. Sometimes the defendant might try and argue and say, well, it's not my fault the victim suffered that harm because they were vulnerable. I didn't know that they had this particular predisposition. And we already are familiar with this thin skull principle from when we've studied criminal law, but in tort, we use the case of Smith and Leach brain. And in this case, our defendant was liable for the death of the victim who was burned on the lip by hot metal. And the hot metal triggered precancerous cells to turn into cancer, and our victim sadly passed away. But the rule from Smith and Leach brain was that our defendant must take his victim as he finds him, i.e. thin skull. So our defendant's going to be liable for injuries that are more serious than might have been expected because of a vulnerability of the victim. And that seems fair, because you shouldn't escape liability simply because the victim or the claimant had an extra sensitivity. Res ipsa loquitur is a more rare situation where we say the facts speak for themselves. And this is illustrated by Scott and London and St. Catherine Docks. And this is where basically the negligence is so obvious, we say it's res ipsa. And you've got in your booklets the 3 rules that need to apply here. Res ipsa is like a tag-on little rule that we always deal with when we're looking at damage, but it doesn't tend to come up in that many scenarios. But the thing caused was under the control of the defendant, the cause of the accident was unknown, and it wouldn't normally happen without negligence, as illustrated by a huge bag of sugar falling from a crane. Mahon and Osborne is another example of that. Some swabs were left inside the body of a patient after an operation. That's clearly res ipsa. The thing speaks for itself. That could not have happened if it wasn't for negligence on the part of the surgeon. So we've looked at all our cases on damage then. So I want to end with this summary slide here, which shows you what I've just talked you through, that in order to prove damage, firstly, we need to prove factual causation using the but-for test from Barnett, but we need to be aware of multiple causes and new and intervening acts. We also need to prove legal causation or remoteness of damage, and that basically means that the damage must be reasonably foreseeable. Extreme forms, unusual causes are still recoverable. Thin skull applies, as it does in criminal law, that our defendant has to take his victim as he finds him. And res ipsa loquitur is a little rule that we look at, which says that sometimes it's so obvious that negligence has occurred. Res ipsa, the thing speaks for itself. And we saw that in Scott and London. Okay, so that's the conclusion of our 3rd tutorial on negligence. Do look at my other video tutorial on how to apply negligence to a scenario, and I'll go through a model answer on this area as well.